All right. Good morning. Welcome to another morning episode of the Liberty Dad Podcast, a discussion on politics and culture. I'm your host, DL, America's most objective libertarian. If you're tuning in live, thank you so much for giving me your time so early. I want you to remember, folks, remember and articulate, I promise. If you're a candidate and you are running for office, doesn't matter what party, and you want an interview, you want to be on this show, I want you to head on over to candidates.libertydad.com and get yourself booked. The link is in the show notes. Available times are Tuesday and Thursday mornings at 7:30 a.m., Wednesday and Thursday evenings at 7:30 p.m. All times are Eastern. You're probably wondering, like, who's lined up for this week? Well, tonight I have Tanner Lopez coming out of Virginia to talk about his run for U.S. House. And then tomorrow evening, I will speak with Lori Schillings, who is running for Indiana Secretary of State. So look forward to those two episodes. All right, today we're going to talk about judges. You know, I love talking about judges. I like talking about the law. I'm just a lay guy. I'm not a lawyer. No particular training other than just, reading. Simple as that. So I have talked at length that people say, oh, these activist judges. And most of the time, people don't know what they're talking about, right? Like you'll see somebody, they'll deliver a ruling that goes against what Trump is trying to do, and people will say, oh, it's just an activist judge, the Democrat, liberal, progressive judges. And then you go and look and you find out that the judge, had been there for like 20 years. They were appointed by George W. Bush or some other Republican, right? Or more importantly, you read the actual ruling and you're like, yeah, I think this actually makes sense. I'm not seeing activism here, right? And that's not to say that it never happens. Sometimes judges do have an agenda, and that agenda is maybe they want to see particular reform or whatever. So I'm not saying it never happens. I'm just saying that a lot of times people don't know what they're talking about, or their arguments don't seem to suggest that they know what they're talking about. So what do we got today? We're going to talk about two judges. First up, Ketanji Brown. There's something about doing a show in the morning. It's like my mouth has not worked up, gotten itself ready. Like I had my coffee, get all my show prepped, and my mouth is like, yeah, I'm still taking a nap. Anyway, Ketanji Brown Jackson, keep wanting to say Braxton, it's not going to work. So there was a court case yesterday. We'll start with her. It was this ruling from Colorado. So let's take a look at what some internet comments are saying. All right, here we go. We got, where's my music? Where's my music? There we go. All right, so KBJ is the legal token that establishes equal opportunity for retarded race-addled reparationistas. Yeah, that's the word. It's a new word, but it's a word, I guess. She's Biden's revenge, the biggest purveyor of ebonic thought in public life. She's adult, a subliterate cretin as the Dems answer to Justice Thomas. Well, all right, Russell, that was quite a lot there, buddy. Let's see what else we got. The Babylon Bee jumps in on it. KBJ, how can a law be unconstitutional if I like it? All right, fair enough. Mark says, new description for KBJ, kooky, bozo, judge. Okay. KBJ equals DEI equals Dem equals SCOTUS equals 8-1. Because we needed SCOTUS to tell us citizens that teaching little boys that they can turn into little girls is bad. Mm-hmm. We're going to get to that there, Jackson. It's not quite that simple. I know you might. This is why I read the rulings so I can go, is this criticism legit? Or is there a point to be made here, even if I don't like the point? Right? That's how the arena of ideas work. We take an idea, we pick it apart, and then we can say, all right, was this even a valiant attempt at an idea? And if not, then we can say, yeah, this person was retarded. But if there was a valiant attempt, then we should at least give them credit. Say, okay, you made it's an interesting point, but wasn't good enough. Let's see what else we got. Of course, KBJ was the dissenter. The KBJ dissent today is garbage. It's a brutal assault on intellectualism. Now, I think this particular guy, Rich, I think he is a lawyer, so I'm going to assume that he actually read the ruling. So here's the catch. Just because somebody's saying something mean about a judge or anybody in public doesn't mean that they're necessarily wrong. What matters is, why are they saying that? Let's see what else we got here. And both dissents pertaining to sex written by someone who admitted to not knowing what a man or a woman is. Go figure. Justice Jackson is an activist, not a judge. Okay. Maybe. This is activist logic. Decide on the outcomes first and then say some words or write a Supreme Court opinion to get the results you want. Okay? Can you demonstrate that? I don't have beef if someone can, come out, criticize a judge, and then demonstrate why their criticism is fair. I've been around a while, and I've seen how people defend their opinion. I've seen people say this ruling or this study is garbage, and I'm like, yeah, and then I read it, or they'll say it's great, right? They'll be like, this is great, and I'll read it, and I'll be like, but the ruling, the study, the document, whatever it is that you're pointing to, it doesn't say what you said it says. So what does that make you, right? Like, if we're going to talk about activist judges, maybe we got an activist population. Let's see. Ketanji, I always seem to fumble with that name. Ketanji Brown Jackson is the textbook example of a liberal who can't think about what tomorrow looks like or how her actions today might impact tomorrow. Now, this one's interesting because all she did was write the dissent. Like, does anybody ever refer back and they're like, well, so-and-so over here dissented, so therefore you should rule in my favor? I don't know about all that. She lost. I mean, I don't say she lost. The ruling was 8-1. The other 8 justices were in agreement, mostly, and then Ketanji Brown Jackson was not. We're gonna dig into that here in a moment. Last year, Justice Jackson dissented in the U.S. v. Scarametti case, in which she argued that states have no right to ban gender transition on minors. Today, she was the lone dissent in Childs v. Salazar, writing that, quote, there is no right to practice medicine which is not subordinate to the power of states, end quote. And then, let's see, I think he goes on here one more. Yeah. So states have no right to pass laws banning children from changing their sex, but states do have the right to ban counselors from telling boys they are not girls. You truly can't make this up. So we're going to find out today that I'm going to nitpick a little bit, but it's important. So the comment here is he's criticizing Theo here. Theo Wold is criticizing KBJ for saying states have the right to ban counselors from telling boys they are not girls. But that's not really what she said, nor is that really in the ruling, as we're going to read. All right? So let's go over to some documents here. Here's the Supreme Court ruling. Okay? We're going to read through it a little bit, and we're going to learn some stuff. All right? So we're going to start with the summary. Here's what it says. Kaylee Childs holds a master's degree in clinical mental health and a state counseling license in Colorado. Ms. Childs does not begin counseling with any predetermined goals. Instead, she sits down with clients, discusses their goals, and then formulates methods of counseling that will most benefit them, seeking throughout to respect her client's fundamental right of self-determination. So this is where I'm nitpicking, okay? It's not just simply that she wants to go and tell clients, you're a boy, you're a girl, regardless of how you feel right now. That's not what she's doing. She's saying, what she's doing is saying, what is it that you want? So when people say, oh, they're prohibiting this person from telling boys that they're boys and girls that they're girls. That's not quite right. What actually is the argument here, and as we're going to see, is that that Ms. Childs and others were prohibited from discussing something based on the patient's desires. So it's actually even more insidious, in my opinion. And this is what happens when you don't read the friggin' documents. You don't find out, like, oh, this is actually worse than I think it is. Because, and we're going to see this. We're going to go through it. Where it's worse is that if I'm the client, if I go in and I say, hey, I had these feelings, but I also had these beliefs. Will you help me work through them and get to this end point? I want to suppress these feelings. I want to manage these feelings, whatever they are. And then the Colorado said, no, this counselor isn't allowed to do that. So Colorado, what they did was they limited patients from seeking the care that they want. This is more important than, oh, you can't just say they're a boy if they're a boy and they're a girl if they're a girl. This is, the patient says, I am struggling. Imagine a patient saying this. Imagine they say, hey, I feel like I might be a girl, but I really believe, I have these conflicting feelings. On one hand, feel like a girl. On the other hand, I feel like I shouldn't feel this way. Can you help me work through this? And Colorado said no. Let's continue reading. On matters of sexuality and gender, Ms. Child's clients, including young people, often have different goals. Some are content with their sexual orientation and gender identity and want help with social issues or family relationships, while others hope to reduce or eliminate unwanted sexual attraction, change sexual behaviors, or grow in the experience of harmony with their bodies. Okay, so her clients have different desires. They're not all coming in to be changed at the whim of Ms. Childs. And this is important when we're talking about law. Like there are times when you could make an argument and you could say, look, it's not the time to split hairs. But when we're talking about laws which punish people or restrict people, yes, we must split hairs. It is important. Going on. With all those clients, Ms. Childs seeks to help them reach their stated objectives. And she employs only talk therapy. It's just only talk. It's literally two people getting together and one person saying, will you help me work out this issue so I can get to this goal? And Ms. Childs is like, well, I can't. So she took it to court. In 2019, Colorado adopted a law prohibiting licensed counselors from engaging in conversion therapy with minors. Colorado revision statute, blah, 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 defining the term to include, quote, any practice or treatment that attempts to change an individual's sexual orientation or gender identity, end quote, as well as, quote, effort to change behavior or gender expressions or to eliminate or reduce sexual or romantic attractions towards individuals of the same sex, end quote. Yet the law explicitly allows counselors to provide, quote, acceptance, support, and understanding for identity exploration and development, and to assist persons undergoing gender transition. This is going to be key in understanding the ruling. Ms. Childs filed suit in federal court, seeking a preliminary injunction, raising a First Amendment challenge to the law as it applies to her talk therapy. Both the District Court and the 10th Circuit Court determined that Ms. Childs had Article III standing to pursue her as applied pre-enforcement challenge. Okay, so basically what happens whenever you want, when you want to file a lawsuit, the court first determines, do you have standing? Like, are you somebody that this law has harmed, or are you just doing it on behalf of somebody else? If you're doing it on behalf of somebody else, then you don't have standing. On the merits, however, both courts denied Ms. Childs' request for a preliminary injunction, reasoning that Colorado's law is best understood as regulating professional conduct and that it regulates speech only incidentally. That's also key. Whether or not this regulates speech incidentally or intentionally, thus triggering no more than rational basis review under the First Amendment. This court granted, I can't say the word certiorari, I should have looked it up first, to resolve a circuit conflict over how the First Amendment interacts with laws like Colorado's when those laws are applied to talk therapy. Held. Colorado's law banning conversion therapy as applied to Ms. Child's talk therapy regulates speech based on viewpoint, and the lower courts erred by failing to apply sufficiently rigorous First Amendment scrutiny. Okay? So in this summary, they're basically distinguishing between two concepts here: viewpoint and content-based restrictions. All right? That's the end of this. That's the end of the syllabus, right? We don't have any more. Oh no, sorry. I apologize. I'm doing something a little different. So, as applied to Ms. Childs, Colorado's law regulates the content of her speech and goes further to prescribe what views she may and may not express, discriminating on the basis of viewpoint. Her speech does not become conduct just because a government says so or because it may be described as a treatment or therapeutic modality. The First Amendment is no word game, and the exercise of constitutional rights cannot be circumscribed by mere labels. I think that was it, actually. Yeah, that's it. All right, so that was the summary. And again, what they're doing is they're drawing a distinction here, and they're saying we've got content restrictions, we got viewpoint restrictions. This was a viewpoint restriction. So what is the difference? What does this mean? Content restrictions. These laws regulate speech based on its subject matter, topic, or the message conveyed, without necessarily favoring one side of the debate. The government draws distinctions depending on what is being said, that's the content, rather than neutral factors like time, place, or manner of expression. So, for example, a law banning all discussions on politics in a public park, but allowing, say, conversation about sports or the weather. That would be content restriction, okay? Content-based. A sign ordinance that imposes stricter rules on political signs than on ideological or directional signs, okay? It's basically saying the content, all of it, is a big, huge umbrella. Another example would be a regulation prohibiting speech about a specific issue, such as abortion, regardless of whether the speaker supports it or opposes it. Okay, so this is content-based limitation. Then you have viewpoint, which is what the court said happened here. These are specific. They're more targeted form of content-based restriction. So the government not only regulates based on the subject, but singles out particular ideologies, opinions, perspectives, or sides of a debate for disfavored treatment. Basically, it picks winners and losers within a topic by favoring one viewpoint over others. So here's a couple examples. A law that bans criticism of war, but allows praise for it. This would target one perspective on the topic of war. Okay, this would be a viewpoint-based discrimination. Another example, a university policy denying funding only to student groups expressing religious viewpoints while funding secular ones on the same topics. Okay, that would be viewpoint discrimination. Then you have a rule, in this particular case, a rule allowing therapists to discuss sexual orientation or gender identity with minors only if they affirm or support certain outcomes, but then prohibiting discussions aimed at helping clients reduce unwanted attractions or align identity with biological sex. So you understand what's going on. This is what this whole case is about. This is why it went to court. Hey, you're allowing these therapists to confirm somebody's gender identity, but if a patient comes to me and says they would actually like to confirm their biological sex and they're having trouble with it, you have said, I can't have this conversation. Therefore, this is viewpoint discrimination. That's what happened. That's what this whole case is about. So let's continue reading here. According to Ms. Child's verified complaint, she holds a master's degree in clinical mental health and a state counseling license. By the way, this is the opinion of the court delivered by Justice Gorsuch. Clients seek her help on a wide variety of mental health issues, including trauma, addiction, eating orders, gender dysphoria, and sexuality. Ms. Childs does not begin counseling on any topic with any predetermined goals, nor does she seek to impose her values or beliefs on clients. So again, She's only responding to what clients are asking of her. Instead, she sits down and talks to them about their goals. Only after clients have identified their own aspirations does Ms. Childs begin formulating methods of counseling that will most benefit them. On matters of sexuality and gender, Ms. Childs' clients, including minors, come to her with different goals in mind. Some are content with their sexual orientation and gender identity and seek assistance only with social issues, family relationships, and the like. In cases like those, Ms. Childs does not try to persuade her clients to change their attractions, behavior, or identity, but aims instead to help them address their stated goals. Other clients, however, come to her hoping to reduce or eliminate unwanted sexual attractions, change sexual behaviors, or grow in the experience of harmony with their bodies. And in these cases, too, Ms. Childs seeks to help her clients reach their own stated objectives. In doing so, she does not prescribe any medicines, perform any physical treatments, or engage in any coercive or aversive practices. All Ms. Childs offers is talk therapy. She's literally just talking them through it, helping them out. That's it, okay? So, pretty simple. She's not trying to persuade them. She's just saying, like, what is your goal? And then the government, Colorado, said, well, if they didn't say it like this, but they said, you can't go in this direction. You can't say these things. And then she's like, well, that means you're picking winners and losers, because I have clients on either side of this coin. I have clients that sometimes want me to talk them away from certain things, and there's other clients that want me to talk them through it and maintain it. And you're telling me that I can only practice my profession with one of those. So you're limiting me. All right, now let's get to Kagan's response, right? So Justice Kagan, who Sotomayor was joined, they wrote, so they were joined with the majority, okay? Because remember, this was 8-1. However, Justice Kagan wrote her own opinion, like in addition to. And I think this is very, very important for us to understand. Here's what she said. I write only to note that if Colorado had instead enacted a content-based but viewpoint-neutral law, it would raise a different and more difficult question. Right? Continuing on down here, it says, so for example, the law prevents a therapist from saying she can help a minor change his same-sex orientation, but permits her to say that such a goal is impossible, and so she will help him accept his gay identity. The law distinguishes between two opposed sets of ideas, the one resisting, the other reflecting the state's own view of how to speak with minors about sexual orientation and gender identity. Or, said just a bit differently, the law draws a line based on speaker's opinion or perspective and thus enables speech on only one side, the state's preferred side of an ideologically charged issue. So they're basically in agreement, and they're confirming, like, yes, this is what's happening. We're drawing a distinction. But it was this first comment here that really caught my attention. Because a lot of people are like, even Kagan and Sotomayor agree with the majority. Why this Jackson, she's way out left field, which she is in a sense, and we'll see that in a moment. But I think people are underappreciating what Kagan has actually said here. I'm going to repeat it really quickly. I write only to note that if Colorado had instead enacted a content-based but viewpoint-neutral law, it would raise a different and more difficult question. So let's be clear. In this particular ruling, Kagan and Sotomayor, they are not necessarily 1A, First Amendment stalwarts. They rightfully recognize that, yes, the Colorado law violated the First Amendment regarding viewpoint speech, which again, which side of the content one lands, but makes a point to suggest there is a small opportunity for legislators to draft legislation that could be upheld by shifting to content-based limits. In other words, by the topic, regardless of what the position is. So they could. There is, in other words, let me put it more simple. There is an opportunity here according to Justice Kagan, that the law could be rewritten so that it's content-based, not viewpoint-based, and still limit Ms. Childs. That's what she's saying. She's not like drawing it out, but that's what she's saying. Now let's move on. We're going to talk about that more in a second. Let's move on to Jackson's dissent here. So here's what she said. And here's what I think you should understand before you criticize Jackson, what she's saying. Okay? So she says, many states have now chosen to exercise their police powers to ban conversion therapy based on the medical profession's broad consensus that this medical treatment, which seeks to change a gay or transgender person's sexual orientation or gender identity, is ineffective and harmful. Okay? So she's leading off with this notion of, hey, states have police powers. They have powers to regulate. You might think of it like regulation powers. Okay? Going down, I respectfully dissent. Stated simply, the majority has failed to appreciate the crucial context in which Childs' constitutional claims have arisen. Childs is not speaking in the ether. She is providing therapy to minors as a licensed healthcare professional. This is very important. She goes on and says, no one directly disputes that Colorado has the power to regulate the medical treatments that state licensed professionals provide to patients, nor is it asserted that when doing so, a state always runs afoul of the Constitution. All right, I want you to, let me repeat that. Nor is it asserted that when doing so, a state always runs afoul of the Constitution. Now, we just read Kagan said, hey, there is an opportunity, there is a narrow opportunity here where if you rewrote the law, it would be fine, potentially. Now, content-based limitations, right, when it comes to the First Amendment, that's not a guarantee. Okay, so just because you make it based on content doesn't guarantee that it's going to pass constitutional review. Okay, that just means you got a little bit better chance than if it's review-based, because review-based going to get tossed out every time. So then she goes on and says, so in my view, it cannot also be the case that Colorado's decision to restrict a dangerous therapy modality that, incidentally, involves provider speech is presumptively unconstitutional. In concluding otherwise, the court's opinion misreads our precedents, is unprincipled and unworkable, and will eventually prove untenable for those who rely upon the long-recognized responsibility of states to regulate the medical profession for the protection of public health. Basically here, let me change my screen here real quick here. All right. Basically, Jackson argues the majority is overreading the First Amendment protections in the doctor-patient or counselor-client relationship, eroding the state's traditional role in safeguarding public health through licensing and malpractice-adjacent rules. That's basically what she's arguing. She didn't. Now, you can argue and say, hey, she just liked the law and then she was finding a way to defend it, and that's fair, but we should understand exactly how she's doing this, okay? Because again, according to Kagan and Sotomayor, if the legislation were framed to prohibit therapies that, say, lacked evidence-based support, you might think of like, imagine the APA or some other institution has a guideline, then it's possible that conversion talk therapy could be prohibited while gender-affirming talk therapy is permitted. So Justice Kagan, Justice Sotomayor were like, look, we agree this violates viewpoint limitations. However, there is a narrow area under content limitations that this might work. And then Jackson comes along and she says, look, I think you guys are overreading the First Amendment. I think that's crazy, by the way. But she says, I think that you're overreading the First Amendment and we're ignoring the fact that states have the power to regulate licensed professionals. So she, in a sense, is kind of reiterating what that small little portion of what Kagan and Sotomayor agreed to, which is the state has police power. So the idea that Ms. Childs is necessarily out of the woods it's not true. And maybe this is a situation of activist judges, but I think it's a little deeper than that. Perhaps not much, but a little bit. The decision ultimately reinforces that the First Amendment doesn't vanish inside a licensed professional's office when core expressive activity is at stake, right? Like, in other words, this is what I do. Any person who accepts a public role is subject to scrutiny, even mockery, including Supreme Court justices. But again, when it comes to judicial rulings, it's always wise to know exactly what it is that we're mocking and any potential concerns in the future. This case, I think, squarely falls on the First Amendment. But there are future concerns that more progressive legislatures could impose. And we can see at least 3 Supreme Court justices might favor those arguments. It's unclear how the rest would, depending on how the legislation was written. But it's clear that at least 3 of them might support, you might call it similar but better written legislation. Now, here's the deal. In a libertarian world, there wouldn't be state-sanctioned licensing. Or, if there was, it would be extremely limited. So we'd like, all right, you're cutting hair, you don't need a license. You're operating on brains, you might, okay? In a libertarian world, depending on which flavor of libertarianism you get. But in the libertarian world, we either wouldn't have it or it would be extremely limited, and there would be far more deference to free speech and consenting clients. In a libertarian world, we would say, if I'm the client and I go to a counselor and I say, this is my goal, I would like you to help me work it out. In a libertarian world, that wouldn't be in question whatsoever. And you could not have a law that says, no, you cannot do that. You know, particularly with adults. Children, you know, there might be a little different story there, right? We do have some different views when it comes to children because children cannot consent. Adults can consent. So I can talk to anybody about anything. Children are a little different. But that's how it would work in a libertarian world. But I wanted to review this because I thought it was very important that we at least have a simple understanding of what this legislation is about. I have no problem criticizing any Supreme Court justice, any president, any legislator, anybody that's a public figure. But I do think that we should not be superficial so that we understand what could happen in the future. And that way we can be prepared. Because what happens when Colorado rewrites that law and people are like, oh, this is going to get kicked out. And so they ignore it, right? I mean, I'm making a presumption here, but assume that Colorado rewrites the law so that it's content-based limitations. And a lot of people look at it, they go, yeah, the Supreme Court already ruled on this. This is going to fail. And so nobody does anything, right? And then it goes through the legislature. Then they pass it. The governor signs it. It becomes law. It gets challenged because all the yokels out there were busy laughing and going, ha, ha, ha. The Supreme Court already ruled on this. It goes to the Supreme Court again, and the Supreme Court comes back and says, well, this one actually stands because it's content-based, and the way that it was written does not violate the First Amendment. Because what if the court comes back later and says, well, it is indeed true that, yes, states have the power to regulate licensed professionals. And this is just simply them making that regulation in a way that doesn't violate the First Amendment. What happens then? Do you see the problem? The problem is, if you want to stop it, you have to understand what the Supreme Court has ruled in the past so that you have an idea of how hard you need to fight against legislation. Because the last thing you want to have happen is have a legislature pass legislation that you don't like and then find out that even the Supreme Court agrees and says, look, we're not taking a position on the legislation in itself, but it is constitutional. Then you have to go through the process of trying to undo that legislation. Do you see why it's wise to actually read through some of these rulings and understand? We've got to do more than just simply mock people. We have to understand why we're mocking them, and then we have to understand, like, is it fair? Is it unfair? Whatever. And then in the future, if something comes up, because we were wise in the first place and we understood what we were mocking, we could say, ooh, this might actually pass. Unlike the last one, we better fight really hard against this one. I think that's very important. Let's see here. Keith says, thank you for your work, DL. I appreciate it, sir. Put a lot of energy in it. Let's go to a quick intermission here. And when we come back, we're going to talk about another judge here in Florida. Be right back.
The day I got cited, I was blindsided.
I couldn't believe that I was in America. I left a place where that stuff happens, but not here. Here, this is the land of opportunity.
I didn't do anything wrong.
I just couldn't believe it. I didn't do anything wrong.
You think that you're doing things the right way. You think that you're a law-abiding citizen.
And they said I was under arrest for braiding hair, and they took me to jail.
They seized a little over $100,000 out of my business account here. Took 13 years to get it and less than 13 seconds, I guess, to take it away.
I remember my attorneys telling me, most people don't win against the government.
Because I know now that we have more than just a chance. I know that we're going to keep our homes.
If we win here at the U.S. Supreme Court, it makes a difference for my girls and for so many other families.
I'm fighting back because I don't want to have a lot of other people have to go through the same thing I'm going through with their property getting seized.
We changed the law so that everybody else can be treated fairly.
I want the opportunity
To operate my legal business.
To practice my craft.
To meet the needs of my community in an innovative way. And someone has to stand up.
Right, we are back, and I forgot to give you this announcement. It's not 100% sealed deal, but I think it's pretty solid. This Saturday, I'll participate. I'm not sure if it's going to be an actual debate or just a conversation, but it is going to be moderated, so perhaps a debate. The topic is going to be, it is better to pursue the minarchist acceptance of a government monopoly on law enforcement than an anarchist approach. Okay? And what does that mean if you're like not a libertarian? You're like, what is that jargon that you're using there? So an anarchist believes in no government in the way that we have it. That doesn't mean no rules necessarily. That just means everybody comes together to voluntarily agree upon the rules. And minarchists are like, look, there's some flavor of acceptance for government. Some of them will argue that we absolutely need at least a minimal government. And then some of them, like myself, say, it's not so much that we need one, it's that we're always going to have one. And so therefore we should continually fight for the smallest amount of government possible. That's where I land. And then you might say, well, how small? Yes, just keep going. Just keep going till you can't go anymore. And the way that I see the world, it's a continual battle anyway. So look forward to that. I'll announce more on that as I get more information, but I believe that's going to happen Saturday night. So look forward to that. All right. This next one, let's see what the internet is up to here. So we've got breaking. Governor Ron DeSantis is moving to get a radical leftist judge impeached after she released a known predator who went on to kill an innocent 5-year-old girl. Yes. Start a nationwide trend fire, right? And then he goes on and he says, DeSantis is petitioning the state legislature to impeach Judge Tiffany Baker, quote, until you start holding these judges accountable, they are going to continue to find ways to benefit the criminal element, end quote. And then he finally ends this post by saying, this was an outrage. This was such an easy call to make sure that this guy was put behind bars, and this judge refused to do it. Impeach her and start impeaching nationwide. America, right? So how do people respond? Said DC Drano. says, we are finally starting to hold these woke Marxist judges accountable. I just want to point out all that's happened so far is that Ron DeSantis said we should do this. Nobody's been held accountable yet. It's just like we should. Impeach them until they start following the tenets of real justice, not social justice. BS. Okay, we'll see about that. We'll see about that there, DC. Jules Jones said, impeach. All caps. Thank you, Governor Ron DeSantis. This is the kind of leadership needed all across our nation. Florida legislature needs to do its duty. Okay? DeSantis is still the best and boldest conservative leader of my lifetime. How old are you? You like 20? I feel like I could find a few better ones, but hey, whatever. Bartenders are held accountable for over-serving if someone goes on to drive drunk. Judges absolutely need to be held accountable if a criminal they release goes on to murder someone. These activist judges have blood on their hands. This is true, but when bartenders are held accountable, this is because of the law. This is not a matter of just simple discretion. So there is a difference there, Lauren. Let's see. Sean, good. These judges need to face consequences for the hell they unleash on the rest of us. Okay? Dr. Manhatva, why can't Utah do this? Serious question. What law firm is advising our legislators on the Hill? I think a lot of your legislators are lawyers, and they have retained counsel, like people that are literally hired to be advisors. So just saying, there's not like a law firm that they just reach out to and say, hey, what do you think? Just in case you were curious about how your government works before you start demanding they do things. Every elected Republican should take notes on what DeSantis has and continues to do in Florida. This is how you defend our country. Okay, and I just once again point out, he hasn't actually done anything. Okay? Nothing has actually happened. He just said the legislature should do this. So, what did he say? Let's take a play. Let's play the video. Let's watch it. Here's what he said.
I appreciate the legislature for passing this, but I will just say...
He's talking about Missy's law, by the way, which is a law which we'll get to in just a moment.
To my friends in the Florida House of Representatives, I don't think what you've done is enough. You have the power and you have sufficient numbers in your chamber to impeach this judge, Tiffany Baker. Until you start holding these judges accountable, they are going to continue to find ways to benefit the criminal element. This was an outrage. This was such an easy call to make sure that this guy was put behind bars, and this judge refused to do it, knowing the risks, and the result has obviously been a tragedy. So Florida Constitution vests the House of Representatives with the ability to bring an impeachment against a circuit judge with 2/3 majority. You know, last time I checked, we've got way more than 2/3 of Republicans. Honestly, I think some Democrats would vote to impeach given what happened in this case.
Okay. So what is this case? What's it all about? It involves the Leon County Circuit Judge Tiffany Baker-Carper, Daniel Spencer, and the death of 5-year-old Melissa Missy Mogul. Here is the timeline of what happened. February 16th, 2024, Daniel Spencer, he was then about 34, 35. He's arrested by the Leon County Sheriff's Office during Operation Spring Cleaning, the cyber sting operation. He's charged with traveling to meet a minor that he believed to be 15 years old for sex and some related offenses. I don't know what those related offenses are, and which is a second-degree felony. February 17th to the 19th, 2024, he appears in court. Bond is set at $3,000 by County Judge Gordon Schuler. He posts bond and is released from the Leon County Detention Facility on February 19th, 2024. Then in July, roughly, Tallahassee Police Department and Department of Children and Families, DCF, investigate separate allegations that Spencer sexually abused his 5-year-old stepdaughter, Missy Mogul. Both agencies closed the case without charges due to insufficient probable cause. April of 2025, April 15th. After a one-day trial in Leon County Circuit Court before Judge Tiffany Baker-Carper, Spencer is convicted by a jury of traveling to meet a minor. Okay, remember, the minor's 15 years old who he thought was 15. Prosecutors request he be remanded to jail pending sentencing. Judge Baker-Carper denies the request, noting on the record that Spencer had been out on bond for over a year with no violations and no apparent violent criminal history presented to her. She invited prosecutors to provide additional information if she missed anything. Then Spencer remained free. So in 2025, everybody's arguing, they're like, oh, she let him out on purpose. Yes, because she said, do you have any evidence that this man cannot be released as we might normally do? He was already out for a whole year and we haven't seen any signs of violence, right? And she's not the one that let him out for a year. He posted bond and he was out for a year with no problems. There was a report, but then it was closed because we don't have enough information. Okay. May 19th, 2025, Missy Mogul. She was born in 2019. She's found unresponsive at the family home in Kipling Court in Tallahassee's Southwood neighborhood around 7:44 a.m. She showed extensive signs of severe abuse, bruises, burns, ligature marks, etc. Missy is pronounced dead at Tallahassee Memorial Hospital at approximately 8:34 a.m. Daniel Spencer and his wife, Chloe Spencer, that's her biological mother, are arrested later that day on initial charges including aggravated child abuse, child neglect causing great bodily harm, and failure to report child abuse. May 2020, between May 20 and May 27 of 2025, Spencer and Chloe Spencer make first appearance. I think I wrote that wrong. Are ordered held without bond. Charges are upgraded by May 27th. Both face second-degree murder charges in addition to the abuse counts. In June 2025, Judge Baker-Carper revokes Spencer's bond in the sexting case and holds him without bond on the new murder charges. Public criticism of her April 15th bond decision intensifies, with state attorney Jack Campbell stating Missy would likely be alive if Spencer had been jailed. Look, there is no nice way to put this. There's no delicate way to put this. We could find 17 ways to Sunday that would have kept Missy Mogul alive. If we just had, I don't know, if we had people that were vigilantes out there, perhaps she'd be alive, right? If the mother had done this, she'd be alive. If. We can if all day long. But at the end of the day, we have to determine what was the basis for the decision, how consistent was it in our court system, and whether or not that judge was acting like as we normally would expect a judge to act, or are we just angry because we don't like what ended up happening? It's the latter. June 24th, 2025, Attorney General James Uthmeyer proposes Missy's Law to require judges to remand defendants convicted of certain dangerous crimes, including sex offenses against minors, into custody pending sentencing, limiting discretion in such cases. So basically, he's like, look, we're going to propose this law, Missy's Law, that just says, judges, you no longer have discretion in these particular cases. I haven't read the legislation, but just on the surface, I think that's a good thing. Why is that? Because if you allow discretion, then that means somebody might get let go, right? They might be permitted to roam free. Somebody might not. That's the whole point of discretion. It's kind of like when somebody asks you a question, they're like, hey, will you come over and help me move? And you're like, no. And then they get mad at you and you're like, you asked me. You gave me an option. I made an option. Why are you mad at me? Because you don't like the outcome. That's what's going on here. People don't like the outcome, and so that now they're mad at the judge for using her discretion. And when I look back and I see that, oh, you asked for more information before you said, we'll let this man go, and you let him go because he had already been out a whole year, and he hadn't shown any signs of violence. Many men, vile and disgusting as it is, they go to meet children, 15-year-old children. But that doesn't necessarily make them violent. That doesn't necessarily mean, hey, they're going to kill somebody. That's a whole other issue. And we need to recognize that. In July of 2025, a Leon County grand jury indicts both Spencers on upgraded charges, including first-degree murder, aggravated child abuse, and other counts. Prosecutors announced they will seek the death penalty. February 2025, this year, the Florida House passes Missy's Law, HB 445. And then in March, early March, the Florida Senate passes the bill unanimously. March 31st, Governor Ron DeSantis signs Missy's Law into effect during a ceremony in Tampa. That's where we got the video. At the signing, this is again where we are today, he publicly calls for the Florida House to impeach Judge Tiffany Baker-Carper, describing her April 2025 decision as, quote, a miscarriage of justice and, quote, dereliction of duty. This is where I have a disagreement in the dereliction of duty. It's easy to look back and say, hey, this man killed this child. This is vile and disgusting. It's awful. And it's easy to look back and say, woulda, coulda, shoulda. But the truth of the matter is, the judge doesn't appear to be acting as an activist. It doesn't appear that she was like, we need to let this guy go. When she asked for more evidence before making a decision, when she pointed out he had already been out for a year walking around, he solicits a 15-year-old, which he doesn't realize are police officers undercover. He goes to meet. He gets busted. He goes to court. He posts bond. He's out for a year. And then he kills somebody. Look, I know it's tough. I have, since I've become a father, I have a different attitude toward children. As a libertarian, I was once upon a time, moving away from the death penalty because I don't really like the fact that, the government could do it. They could get it wrong, and then there is no undoing it. However, when it comes to children, I'm quite soft on that one. I'm like, well, maybe the death penalty isn't so bad when you harm children, right? That's where I am. So if you harm a child, and these two, they're going to be tried and, seeking the death penalty. And if they get a fair trial and they ended up, getting convicted and they end up getting sentenced to death, I'm going to sleep just fine. And I'm okay with this. And I know it's kind of heresy in the libertarian community, but that's where I am. Because I do believe that we should absolutely do what we can to protect our most vulnerable. At the same time, the system that we have to protect us, to punish us when we're wrong, that also has to be protected. It's in a different category. I'm not comparing it, but it has to be protected. We cannot allow ourselves to emotionally damage what system that we have that is supposed to protect us. What we should do is look for ways to improve it, ways that will benefit the community, ways that will ensure our freedom is protected. But at the same time, if you need punished, you get punished. Period, and plain and simple, right? Going on, so Attorney General James Uthmeier sends a letter to the House Speaker Danny Perez urging immediate impeachment proceedings. No formal impeachment articles have been filed as of this date. They haven't been filed. Now here's where I'm going to kind of dash your hopes, perhaps, with some reality. Judge Tiffany Baker-Carper probably will not be impeached, much less removed. Why would I say that? Removing a judge is very rare. In Florida, since 1838, only 4 judges have been impeached in this state's history, and none were convicted and removed by the Senate. None. 0. In over 100 years, well, roughly about 100 years, no judge has been removed. Florida Circuit judges like Baker-Carper can be impeached by a 2/3 vote of the House with a trial and then removal requiring 2/3 in the Senate as well. However, the primary disciplinary path in Florida is the Judicial Qualifications Commission. They investigate complaints and can recommend discipline short of removal. So they can recommend it. That's the investigation. That's the professional, legal, investigative body. They're the ones that would go through and say, was there, some level of misconduct? Was there some reason that we can recommend and say removal is appropriate? The real question is, should Baker-Carper be impeached and removed? And I'm going to say no for 4 reasons. Number 1, this is probably the most important one. Well, maybe it's not. I don't know. I think they're all relatively important. But number 1, the decision was a discretionary call, not a clear, quote, misdemeanor in office, which is grounds for removal. In Florida's Constitution, Article 3, Section 17, it allows for the impeachment of circuit judges for, quote, misdemeanor in office. This historically targets corruption, willful misconduct, ethical violations, or patterns of abuse, not an isolated ruling that, in hindsight, proves tragically wrong. It's not what it's for. Baker-Carper's ruling occurred after a 1-day trial conviction for traveling to meet a minor. A very serious offense, but is not violent. It's not a violent felony at this point. She noted on the record that Spencer had been out on bond for a year with no violations and no apparent violent criminal history presented to her. On what basis can you look back and say, well, she should have known this was obvious? Because again, how many people are tried and convicted for the same offense, are out on bond, and don't kill anybody? Most of them. Most of them do not do this. So for people saying, oh, kind of acting as if the judge should have known better or it was obvious. No, it wasn't obvious. It's obvious only when you look at the outcome, the end result. And then you go, well, it was obvious, but it really wasn't obvious. Here's what makes something obvious. Tell me how it was obvious at the time that the judge made the decision without any knowledge of what would happen. People can't do that, right? They can make the argument, say, well, it was a very violent, it was a very terrible offense. You can make that argument, right? But again, there's discretion that's involved, that's been granted legally, and discretion has been used by other judges, possibly even the same judge for similar cases. Again, she explicitly invited prosecutors to provide more information if she missed something. So she went out, she was like, look, what else you got? I'm willing to hear you out. That's not what an activist does. An activist doesn't, they ignore information. They override information. They don't seek more of it. The prior DCF and police investigations into alleged abuse of Missy were closed with no probable cause or charges filed. So they weren't even active facts before her at the hearing, her being the judge. She didn't have them. She couldn't look and say, oh, based on these facts, I probably should keep you, I probably shouldn't let you out on bond. Hindsight reveals a catastrophic outcome, but the record does not show bribery. It does not show defiance of clear law, and it does not show a pattern of reckless releases by this judge. Look, you guys are operating on emotion here, and that's not a good thing. Impeachment here would stretch misdemeanor in office into a, quote, bad discretionary judgment with bad results. In other words, they would basically say, hey, if you have this discretion and the results are bad, and then we call that a misdemeanor in office, that risks turning every unpopular or bad ruling into a removal proceeding. Is that actually a good thing? No, it is not. The second reason I oppose this: separation of powers and checks and balances require restraint. The 3 branches exist to check one another, not to let one dominate the judiciary over policy disagreements or single cases. So we don't want the executive or the legislative branch dominating the judiciary branch just because we don't like a ruling or because a particular ruling had an outcome that we could not have foreseen. Judges have to be able to exercise independent judgment under the law as it stood at the time without fear of political retaliation for every tough call. This won't be the first one. You can go back, you can find dozens and dozens, probably hundreds and thousands of cases where the call was tough. Many of them did not have an end tragedy. Some of them perhaps did. The other thing, the executive has already acted forcefully. They signed Missy's law that removes discretion in these kind of cases. Again, on the surface, without actually reading the law, just hearing what I'm hearing, I'm okay with that. I have no issue with the legislature saying, you know what? This discretion turns out not to be a good idea. Let's remove the discretion, right? And then that's how you resolve it going forward. There is no amount of change to the legislation. There's no amount of punishing people that will bring Missy back. None. So now we have to look at it. We can say, all right, is this a good and wise decision? And we can't make it simply on the basis of an outcome that is a tragedy. We also have to look at our system and what we have to work with and how this will impact future cases. This is the proper legislative process, right? You change the rules to prioritize public safety, especially for child predators, right? You say, hey, look, you know what? Even if it only happens 1% of the time, we don't want these people out on bond. And that's fine to acknowledge that, to say, hey, look, it doesn't have to be the majority of the time. Although if it gets to that point, then we definitely need a law. But we can pass laws in some cases and say, you know what? In this particular case, for these particular things, we're not going to let you out on bond. And we're going to hold you until we've finished the legal process. And then if you have been exonerated or if you've been found not guilty, then we will let you back out into public in certain circumstances. And I'm okay with that, particularly when it comes to children. The third reason, the evidence of culpability here is mixed. Again, no evidence shows that Baker-Carper ignored clear statutory mandates. She didn't. Okay? Information on risk weren't fully presented or documented as a violent history. In other words, there was nothing to say this man could harm somebody. It's kind of like when you're watching Law and Order and they're like, is he a flight risk? And they're like, no, he's not a flight risk. And then they're like, okay. And then they don't detain him because they're like, he's not a flight risk. It's the same concept here. Is this person violent? No, they're not. Then I can't hold them because they might be violent because there's no evidence that they would be violent. Impeachment, again, wouldn't undo the tragedy or guarantee better outcomes. It would simply signal that emotional public outrage, which is justified, overrides due process for our officials. Look, I want due process, you presumably want due process. I want due process even for our elected officials. And the fourth reason is the broader goal of justice, safety, and liberty. A functioning state government serves justice by deterring and punishing predators swiftly while preserving fair trials and independent courts. It is really important that we have independent courts that can make a decision based on the law, based on the facts and the arguments presented to them. Missy's law directly advances child protection without gutting judicial discretion entirely. Impeachment will simply feel satisfying, but it risks overcorrection, making courts a tool of momentary politics rather than law. We have to understand our legal system. We have to understand why it does what it does. And when there's an opportunity to improve it, then we do. Now, keep in mind, Judge Baker-Carter, I guess, was not voted in by the executive branch. She wasn't an appointment of any kind. She wasn't voted in by the legislature. She was voted by voters, 58% to 42% back in 2020. She's filed to run again. She filed back in January before this popped up. She filed to run again for re-election this year. If, and this is a big if if the legislature were to successfully impeach and remove her, then it's likely that DeSantis would appoint a replacement. Given the timing, the replacement would be eligible for re-election and basically treated as a typical incumbent. Right? An incumbent would be more favorable to voters. So let's not mince words here. There's a political angle to this as well. Okay? However, impeachment and removal proceedings, they could take weeks to months, depending on the schedule. So this ultimately undermines, in a sense, the will of the voters. So for me, I oppose it, even though I understand the outrage, and we should be mad. And we should be glad that the legislature passed Missy's law, presuming that we've read it and presuming that we agree with it, right? There's no weirdness or, there's no language in there that has unintended outcomes. We don't want that, right? So again, I haven't read it. I'm just assuming that it simply removes the discretion. And if that's the case, then I'm on board with it. If we are a system of laws, as we claim, then we have to act like it, even when the alternative feels better. We're a system of laws. The law gave the judge the opportunity to use discretion. When we look back, we see that this discretion doesn't appear to be abused, and we see that discretion in similar cases has not turned tragic. So therefore, given the facts of the case, remember that whole, facts don't care about your feelings? Given the facts of the case, I don't believe that we should be seeking to impeach the judge. Nor, more importantly, do I believe that she will actually be impeached, because we have a professional process. It could go to the JQC, and they could review this, and then they could make a recommendation to remove the judge. And then if the legislature were to remove her, then they could say, we're doing it based on a professional entity that has reviewed the case, reviewed the professional standards, and determined without politics involved that, yes, this judge was negligent or whatever, however they would describe it. That would be the proper process. And I would absolutely support that. I also will support Governor DeSantis or anybody else going around and making it very clear to voters, hey, this judge made a bad call. You should get somebody else in. This person over here, they make better calls or whatever, whatever your argument wants to be. I'm okay with that, because at the end of the day, if we're going to put up something for election, then that means everything is on the table. We can make all the arguments, good or bad, that we want. And we can say, hey, we should not reelect this judge because one failure is one too many. Now, I would also argue that that's a particularly harsh standard, but if that's what the voters wanted, well, that's what the voters should get. And I'm all in favor of voters being ridiculously picky. When I go and vote for judges, it's very difficult sometimes because unless you go and read a whole bunch of their opinions, then you really don't know anything about a judge. The most you could do is like look up online and see who is supporting them. Oh, I've got these organizations, these people, they have endorsed me, right? You can look up who their endorsements are, and then you can say, well, I like the endorsements, so therefore I think this is a good judge. I think that's a particularly bad way to decide, but you could do it that way. What I normally do is I either leave it blank, or I will look up the judges. I'll look up their names, and if I see any stories that, that caught the news, there's a chance that I'll say, let's get somebody new in. Now, I read the stories. Don't get me wrong. It's not like I'm just like, oh, you made it. You made the headlines. Therefore, I'm not voting for you. But that's my starting point. And I go, oh, what'd you make the headlines for? Oh, you made it in this particular case. So what I would do if I was a voter, and now I'm not in Leon County, so I'm not eligible to vote for her anyway. But if I were in Leon County and I were to come across this particular judge on the ballot, I would look up and I would say, what did they make the news? Oh, they did make the news. Over what? Oh, over this case? You know what? Let's get fresh blood in. That's what I would do. So as a voter, I would absolutely not vote for Judge Baker-Carper. I wouldn't, because I would say one is one too many. And voters are at their discretion to decide if that's the way, you vote on whatever basis you so please. And I will support that. I might criticize you for it, but I'll support it at the end of the day. So that's where I stand. Ketanji Brown Jackson, I think there's a little more. I totally disagree with her. I think she's wrong. But I think it's worth knowing why she's wrong so that we have an understanding of, okay, if Colorado in the future decides that they're going to revise the law, how might they revise it? And what do we need to be on the look for? What do we need to look out for? And then in this particular case, I don't think she's an activist judge. She wasn't a Biden appointee, as we like to say. She wasn't a Democrat appointee. She was voted in by the public. She appears to have requested more information before she made her decision, and then made a decision based on the facts of the case. And it simply turned out to be an awful, terrible tragedy. And I don't think anybody could foresee it. Everybody can backseat. They can armchair, they could be an armchair judge. But at the end of the day, unless they just happen to have a strict view of things, if they were following the law and precedent and the facts, many people might have made the same exact decision that she did. That's where I am. All right. Let's see. Questions. Keith says, will politicians be held accountable when their actions lead to death of innocents, including those lost to war? Not likely, but he raises a good point. We're all mad about activist judges and how they rule. But do we apply this same anger to those that we elect? Not really. We'll do it if it's on the other team, but we don't do it if it's on our team. And that's why we have the system that we do. All right, folks, that is my show for today. Hope you enjoyed it. Hope you found it informative, inspiring. Please do me a favor. Come back by later. Drop a comment in with your thoughts. Did I miss anything? Do I need to offer correction? Perhaps I get things wrong. It's okay. I'm not an official lawyer. I'm just a guy that reads. I can get it wrong. Perhaps you just want to come in and say, you know what? Thank you for doing that. Thank you for taking the position that you did. It's a breath of fresh air that somebody comes out and lays out a strong argument for or against a thing. Whatever the case is, I'm all ears. But with that being said, I'm out, folks, and I will see you tonight with, who is it that we got again? We've got Tanner Lopez. I'll see you tonight for Tanner Lopez. Have a good one. You know that I'm all about supporting organizations that hold my values. Make sure you head on over to blackgunsmatter.shop. They've got apparel, stickers, and more. Use the code LibertyDad, all one word, at checkout to score a 10% discount. Or just hit the referral link in the show notes. That'll make it so much easier. Remember, I'm not just a voice on a mic. I'm a dad who's working hard to deliver to you the best libertarian content. Connect with me on Linktree, where you'll find links to my Patreon and Buy Me a Coffee, because, every bit helps keep this show rolling. Plus, you can find me on my other platforms to stay in the loop. With your help, this show, The Message of Liberty, will be seen and heard by more people. As always, I appreciate you tuning in and look forward to seeing you in the next episode.